Because everyone knows. We've got world famous or infamous Martin Geddes giving us his latest update on the crazy world of the court.
Thank you. So, as I was sitting on the back yesterday, I kind of imagined today I'd probably start off with some joke about being the entertainment after all of the heavy stuff. But as I was listening to Jeff's talk earlier, I actually realised that I need to give potentially a heavier talk than the one I was going to give, right? So, because I think some of what I've been learning will help you find your way out of these problems. But it requires a little bit of attention to a deeper issue that we may not have paid attention to in the past. So I'm going to talk about 6 things, 5 plus 1, 6, all right? So I'm going to quickly lead you through the structure of what I'm going to talk about, so we don't get lost, yeah? And then go through those 6 things in a bit more detail, right? So this is quite ambitious. I've never tried this before.
Let's do it here. What can go wrong?
What can go wrong? So I was going to give a nice, fun, entertaining talk just about my High Court expedition, which I could easily occupy 30 minutes with, right? That's still part of it. But what we're going to talk about, so the first thing is about thresholds and the boundary between law and not law. That's just when I came to the door earlier, about thresholds, and what happens when thresholds collapse. Second thing is we're going to talk about law as divine covenants, and in particular whether authority can be traced back to some higher power or not, which is going to really matter, and whether truth and justice are somewhere on that path. Okay, so that's our setup. Then I'm going to go through my experience with the High Court and court names, right? So court names are our threshold issue, and I went through a whole experience, I'm still going through it, with the High Court, and how to attribute a conviction to one of 44 possible court names or claims that have appeared in my prosecution. And the outcome of that is that the system is self-justifying. It's not operating within covenant, and it's not traceable. But it turned out that court names were not the thing. Right, so I'm going to truncate the talk about the High Court and judicial review because actually it was something else, right? Which was attribution. So underneath truth is attribution, and we're in an attribution war. And until you see the underlying mechanism that's going on, you can't fix the problem. So I'm going to talk about how courts are actually attribution engines applying a variety of different truth regimes, and they degrade under load. And until you see the structure, you can't fix the problem. You can't get to truth until you see the truth is like the molecule, and I'm dealing with the atoms and the quarks, right? It's so to take it kind of full circle is courts are safety of life environments, you see that for children. But because I started off with a most trivial thing of the parking ticket, I could separate all of the moral stuff away and just focus on the mechanics. And in other areas, like aviation, they have to deal with these different truth regimes because people die. Yeah, but we don't have the equivalent of airworthiness for law. So the idea of lex-worthiness is the thing that we're missing. Right? Courts don't have certificates that say that they're airworthy or lex-worthy, and they could if it was certified the level of attribution that they were operating within. And then the last part, which takes us a little bit back to what Jeff was talking about, which is the emerging discipline of what we might call justice sec. So I used to work in IT, there's information security or InfoSec, and what the AI lets us do, what I've been using it for, is to identify the degradation of these truth regimes in doing attribution and do it automatically. So there's lots of things AI is bad at, like morality, but there's one or two things it's really good at, and this is what it's great at. So it lets us see how the system is deforming under load, where the corruption is coming in and not coming in. So I've got a big aha, which is about some of the things that are happening are actually not corruption. We think they are, and they're not, right? So that's the overall arc of it. Quite ambitious. Let's see how it goes. So let's talk about thresholds first. When I walked through the door today, Gary gave me a big smile. Maria gave me a hug. I wasn't just coming through a door. I wasn't just entering under a roof. I was coming into a circle of friends. It was kind of a change of jurisdiction, yeah? My biggest problem before I went to the door was, should I go for a pee first or should I come in, yeah? So, came in, oh, I'm so glad I came in first, right? It's like now, when we receive a letter in the post, it comes to the post box into our door, it's coming into our private realm. Now, if it's just your standard octopus would like to, market you some overpriced energy or whatever, yeah, that's one thing. If it comes from a court, then it's from a different jurisdiction, and particularly if it's coercive and criminal, we have to know, is this really from that domain, because it's entering into my private space, it's crossing my threshold, yeah, or not? Or is it just a random piece of artwork with legalese on it? Right? How can I tell the difference? So my whole issue arose originally with a single justice procedure notice that had an ambiguous sender and court name, and then a summons which had a different set of court names, and then a court which was another name, and then a whole bunch of other documents with more names and claims, and my inability to reconcile them all. So intuitively I knew that, hang on a minute here, isn't there a little bit of a truth problem? Which court am I in? In law. Well, clearly I'm standing here in a courtroom in Carlisle, but I don't know which court this is. Yeah, it's what statutory authority is this really happening by? So I started to unpack the single justice procedure and all that stuff, but the crucial thing is thresholds really matter. So it's why, for example, newlyweds, the husband will carry the wife across the threshold, is because it's a covenantal matter. She's now under his cover, but as long as they follow the same spirit within the house. Yeah? It's a spiritual matter, that's why you carry across the threshold. So when courts are operating, they're meant to operate under a covenant, a responsibility to a higher power to maintain truth and justice. Everything they do ultimately should be traceable back to those things. So when you get a piece of paper in the post that has a court name that can't be traced back to anything in a statute or in law, and then you do a freedom of information request and say, well, what is this? And they say, well, it's not known to us in law, and it's not on the HMCCS directory. Naturally, you have questions. Is this really law? Or is it what we might call the shape of law? So not the colour of law. Colour of law is where you fraudulently pretend to be law, but it's something that has the surface properties of law. It has the Crown logo on it and the HMCCS website details, but all the substance has disappeared. It's only got the surface form left there, right? So it looks like law on the outside, but the core of it, the covenantal part of it, is this about truth and justice or not, has gone. And it's gone at the very first step, which is the transition across the threshold. So the kind of issues that Jeff was talking about earlier with the kids and the family court are all downstream of that, yeah? Is I've gone up to the very, 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 very first step and said, excuse me, but under what regime is this thing operating? So I resisted in court. I said I challenged it. I did a first judicial review. They didn't process it. I did an appeal. They didn't process that. So I ended up launching a judicial review last autumn, saying I'd love to pay this fine for the motoring matter, parking beside a bush, right? So, and the fact it's something so trivial is perfect. because nobody's going to get wrapped up in, oh my goodness, you've hurt these victims, yeah? I didn't hurt the bush. Right? I promise you, I did not cause any harm to any bushes at any point during this whole matter, right? So the motoring matter is also corrupt, but that's completely separate. Right? It's purely a pretext to step into the system and start to stress and audit the system and pushing back using every mechanism possible in law. So I had a judicial review, which was about my personal motoring case, and all I did was say, could we put the pause button on paying this fine until someone adjudicates which court actually convicted me, if any, right? So, oh, by the way, you didn't process my appeal. So I've not had any forum in which to challenge this. But very, very small thing. Wasn't asking to overturn it, just could we pause it, yeah? Smallest possible thing. In parallel, I was doing what's called a Part 8 claim, which is general law. Nothing to do with Martin. And I refined it over time to a single question, which is, under the single justice procedure, what statute attributes judicial power to the judge rubber stamping this stuff in the background when it doesn't go to court? Right? It's, now, I don't want to get into the details of the mechanics of that stuff, because it turns out that the single justice procedure isn't the issue here. Right? It's got all kinds of problems. There are sequencing issues where courts get seized. It's a complete mess, but it's a distraction, right? So the judicial review resulted in the first order from the court saying, hey, in order for me to adjudicate this and give permission or not, I need all the paperwork. So me and the government legal department go away, 2 weeks of assembling bundles, send it in, and at Christmas I get a permission refused from a different judge, and it has nothing to do with the paperwork. Right, so the government legal department have put in a slightly misleading, very misleading defence, saying I've been trying to evade my conviction and I hadn't appealed, but had appealed, didn't process it yet, but it doesn't matter. Is they invoked all these continuity doctrines to say the show must go on, whether or not we can attribute this to a specific court. And they were giving different underlying theories as to what kind of thing might have convicted me. But I was saying, hang on a minute, you haven't got a straight story here. It's like, and you're fibbing about the procedural history, about what's been going on. Now, so I decided to do a renewal application, saying, excuse me, but this refusal appears to be on not the right basis, yeah? And I let that run through until a week or two ago, and I yanked it a week before the renewal hearing. And I yanked it because in parallel, I've got my defence from the other side on the Part 8 claim. And I've been running all this stuff through AI and trying to understand it, and also dealing with all kinds of other friends who are doing similar kind of problems in courts. And a pattern started to emerge. And I started to develop a little framework to understand what's really going on here. And it turned out that the courts, or the other side, were making all of these claims about to whom or what is this conviction attributable? The statutes in general, the magistrates acting nationally, this local justice area, this court, this event. Hang on, we've got so many answers here. It's all very confusing for me. How do I put these into some buckets? So it turns out that there are 4 buckets you can put truth into, right? There's 4 standards you can evaluate truth against. And the critical thing is that they involve different levels of shortcut. No shortcut, a bit of shortcut, a lot of shortcut, and only shortcut, okay? But it's not the same as cheating. Right? Not the same as cheating. Right? So, a good example of no shortcut is habeas corpus. You've got this person in prison, do you have the receipt? well, it's a good prison, and we brought them here in a really well-maintained van, and the prison guards look after them really well, and they came in voluntarily. No, do you have the receipt for whether this person has been properly convicted? Show me the receipt, yeah? So it's the highest level of attribution required, formal attribution, hard proof. Yeah? So when Jeff was talking earlier about getting all these reports, sort of, you were aiming for hard proof, yeah? It's But there are other ways in which we can deem things to be true. It doesn't necessarily mean we're lying, we're just using a degraded form of attribution. So we go down one level from hard proof to I followed the procedure. That doesn't mean that hard proof would be impossible, it just means I'm lowering my standard for is this true or not. So in my case, we followed the procedure, was the excuse. I'm asking for formal attribution. Which court? Name the court that's convicted me. Well, I would like to, but that's a horrible question. Let's talk about the procedure. So go down a level. Use rhetoric. Everyone does this. A story, yeah. And half of their defence was rhetoric. And then you go down another level again, and you get override. So things like parts of the Senior Courts Act, whatever it is, we've got these rules, and let's just do it anyway. Yeah? Do it because we say so. So it turns out that the problem I was dealing with, one of attribution of authority to court names, traceability, wasn't really a jurisdiction challenge at all. It was only a single instance of a much bigger problem that exists everywhere, which is how do institutions carry on operating given that they've got this massive load and requirement on them to attribute stuff? That they're trying to say this person did this thing on this day to this person within this statute year, that they're just massive attribution engines. That's what courts do. They attribute stuff. And there's an almost unbounded demand for attribution, and there's a fixed supply. Something has to give. Either attribution has to stop, or it has to degrade. One of those two, yeah? Either you say everything has to be formal, and when demand exceeds supply, it has to stop. Sorry, can't do yours. Or they have to use lower grades of truth standard to keep the thing going, yeah? And there's all kinds of doctrines to keep the machine running and override your and my demands for stronger attribution. So the aha moment was realizing that this isn't a problem just about law, it can be applied to economics and all kinds of other domains where people are trying to reason about truth. And they don't see that there's an underlying thing which people's concept of what truth might be is tied to different standards. But the massive judo move, the aha move, is to recognise that just because they're using a lower standard of attribution doesn't mean they're cheating. It just means the system is loaded and stressed, right? So the reason why the motoring case really matters is precisely because it has no moral valence, right? No weight. It's the ideal lab in which to let go of all the moral stuff and focus purely on this mechanical aspect of how the system works, without getting our hearts wrapped up in the children being hurt. Yeah, it's now it matters, but the thing that's happening is we turn up in court and say, "Show me the council tax liability order or whatever. We want formal attribution." The people inside the system say, "Look, we can't do that. We can't process all these objects at that scale and send out all these notices with all the right signatures. We can't do it, right?" They look at you and think you're crazy, and you look at them and think they're evil, yeah. And we talk past each other. So now it doesn't mean there isn't a problem. It just means that the degraded attribution levels, the degraded truth regimes, provide cover for people to come in and tell lies and cheat. But we have to discern between the cheating and the shortcut. And every time we go and say, "You're using a shortcut," they go, "Yes, we are." And we say, "You're corrupt," and they go, "You what?" Yeah. So there's a structural issue going on here where they see us as false accusers, we see them as false accusers, and we can't reconcile it because we haven't seen the underlying system of an attribution war going on, and how evil sneaks in at the bottom. Once the system's degraded because it's so overloaded, because there's so many children or whatever being produced, then you can say, I can sneak in lies, because some shortcuts enable cheating, but some shortcuts are just because of load. And telling the difference is really hard, right? But the first step is, before you can even tell the difference, you need to put it in the right bucket. Which kind of attribution level are we using here? And so I can start to take other people's cases, or I could take, so my older daughter went to a posh private school paid by a friend. I couldn't afford it. They were involved in one of these child abuse scandals. They sent me their kind of post-review apology note, whatever, and I ran it through my automated attribution classifier, and you can see how they evade all the formal responsibility and turn it all into procedural, rhetorical, and override. Yeah, it's so you haven't learned the lesson then. Okay, thank you. Right, it's so my notes again. So where we're at. Right, so attribution war. So when you say like my soma for truth is what you're trying to get towards, but there's a thing we need to go through first. Yeah. Ding. Glad you came. Right. So bad things happen when we allow lies to happen to prevail in court. Yeah. And the more we have formal attribution, which is expensive, the harder it becomes the lies and cheating to prosper. Right? It's, so courts are literally safety of life environments. You know, the child that gets trafficked as a result of them being handed off to criminals, safety of life. Yeah. It's, but what they aren't measured against is the utterly standard safety protocols of every other industry: electronics, construction, aviation. Right? They all have a safety framework, and they all explain how they degrade under load, and what the safety margins are, and the tolerances, and how much risk they will allow to happen within the system, and what the failure modes are. Right? It's law doesn't have that, but it could. Right? It could. So we understand that some things have to be formally attributable. So in my case, I got upset because they were threatening me with prison without having attributed the conviction to a court. So I was on the axis of habeas corpus. The moment you threaten me with prison, I'm entitled to say, which freaking court is it, yeah? Show me the authority you're operating by. And when they start to mumble and dissemble and send me off down some crazy route, hang on a minute, you've got no authority here. And they go, yes, we have. We've got this institutional override rule, yeah, at our lowest level of attribution. And you go, you have, but now you've created this self-sealing, self-justifying world of attribution not connected to truth and justice. You're out of covenant. Sorry. In fact, it's worse than that. Is because it's now self-justifying and the state is now the final arbiter of what's true and just. It's idolatry, and I can't participate. So I can come into your lovely court, but even if you can get the High Court to adjudicate that what you're doing is legal, I'm still not participating, and I'm willing to accept whatever happens to me as a result, because I'm not going to participate in this idolatry. Right? So it's a spiritual war at its heart, not a legal battle. And that's why I withdrew from the legal battle in the JR before it went to the last step. And also before the court could harden its own doctrines and make it harder for other people to deal with this problem. So I've left the gaping hole unpatched just before they were going to put a patch on it. Right? They go, gaping hole, look everyone, I've got all these documents from defence and the court that show the hole, because that's all I needed. I don't need to try to get remedy within the system, because the system is self-sealing. Right? It's, so I don't need to win, I just need to show that it's operating, expose it. but I've now got a language in which to expose it. Yeah, I didn't have that language before. So the thing I think we're heading towards is a new discipline. Now, I know many people are rightly suspicious of the AI because it has no body, no soul, no skin in the game. It always tries to lecture you on each prompt response, and try to drag you back into the mainstream. Its moral scruples are all over the place. Yeah, it's a mess. Yeah, morally, it can be useful. But what it does have inside it is what you might call it's an attribution engine as well. It's a reasoning engine. It just does inference, right? It's just a spreadsheet. It's a statistical spreadsheet. That's all it is, really. Yeah. So if you understand what it can do and do reliably versus what's ambitious, is asking it to classify the court orders, the defence's response, whatever it is, into attribution categories, and potentially what the law requires in terms of attribution. Here's a gap, or here's the space in which they've allowed themselves to cheat. Here's the shortcut, and some of these shortcuts are justified, and some are not. Yeah, so I think we're starting to invent a new sector or a new capability, which you might call justice sec. So there's an attack surface that we're dealing with here of vulnerabilities in our society, right? And we've got attackers who are attacking us, and we're trying to patch up these vulnerabilities. It looks awfully like being an IT director and having hackers everywhere. And there's an existing discipline of information security which has developed all kinds of standards and processes and procedures to deal with that. And all we have to do is take the ones from InfoSec or airworthiness directives and apply them to the legal sector. This is an engineering problem. Right? Underneath all these moral outrages that are happening is an engineering problem, and it's a solvable one. Because all we have to do is classify what level of attribution of truth, what truth regime is acceptable, and sometimes degraded are good. So if there's a civil emergency, then habeas corpus gets suspended because allowing all the prisoners out because you can't find the receipts fast enough is bad. Yeah, it's you don't let the murderers out just because there's a flood. Right? It's okay to suspend the requirement for receipts for a while. Right? So degraded attribution in truth regimes is not evil itself. It's not corruption. And if we misclassify it, we get in trouble. But there is a way in which we can start to fix the system. And some of you might have heard a thing called Beiser's paradoxical theory of change. So a guy called Arnold Beiser, Gestalt theory. And what it says is we only change when we fully identify what is, not what could be or what should be. So rather than putting willpower into giving up smoking, you just keep a track without judging yourself of when a date has left you because you smell too much, yeah? Or whatever, or how much you spent on cigarettes. Don't judge it, just write down how much you spent, that's it. So identify fully what is. So what we're doing here is, rather than condemning the system, is we help the system to see what it is in terms of where it is having to take shortcuts under load, and stop condemning it for taking shortcuts under load, because it has to if we want the system to carry on going. Right? Now, in places, some of the system should be trashed and thrown away. Right? So TV licensing, whatever, throw it away. Yeah. Take the load away. Other places not. So it provides a middle space where we can actually start to find each other by showing the dynamics of the attribution dynamics of the system. So I can finally go full circle. Right? I don't need an answer to my court naming problem, because fixing that is the very, very, very last step of a repair process in the structure of law. I don't need to get justice in that problem, right? Because that's the hardest of all of them. The threshold issue, if they admit that all single justice procedure cases were void, because the single justice procedure notices were sent out with botched court names, that's a massive scandal. Yeah, it's like they can't do that. They can't fix that on day one. They have to start somewhere else. Right? It's just not doable. There's no point in asking for it. No judge is going to say, let's shut down the single justice procedure because there's an attribution failure. They'll get fired. So don't ask for it. Right? Find something else you can fix. But this gives you a toolkit, and I've published the framework as what you might call an executable essay up on Substack. There are quite a few of these executable essays because effectively it's code. It's code written in English. It's like a little closed system that can evaluate anything you put into it. Newspaper articles. Run this through the attribution framework and tell me what types of attribution qualities they're using. Very revealing. So there's tools we can put in people's hands. The AI is transformational, but not in the way I originally imagined. Yes, we could use it to, quote, fight the system, but the first step is to map the system, yeah? Is to understand how it's really working mechanically. And the great paradox is you have to take the morality out of it first to put it back in. Right? It's only by having a neutral, non-normative framework of attribution that you can start to solve the problem. Because the moment you turn up and say, you bastard, you're corrupt, well, you might be, but I've gone too far too fast. Yeah, it's like, and that's why we keep losing. Because the people inside the system feel that they're doing their job, and we're judging them, but we haven't created the middle space where this trade-off, the trading spaces of truth regimes can be made non-embarrassing, non-shameful. It's just a fact. When you load the system up, it has to be great. Right? So that's my big aha, and that's why I'm not giving you a half-hour talk about the judicial review, fun as it might be. Okay, questions?
Oh, hi there, Martin. Thanks so much. This isn't so much a question as a word I want to bring into today, and that's nuance. So I think we need to be really careful because, well, we had the gentleman, didn't we, who's got friends setting up a children's home. Now, I've got friends who work in social services, and I know they're not evil people. Mm-hmm. So thank you for bringing, I feel that what you're doing with what you've just explained highlights the problem, this trap, of if we fall into the labelling that precisely the mainstream media would have everyone doing, which divides, which means we lose sight of these nuances. And so I just wanted to say that, thank you.
So there's something you're hinting at, which is the spirit of the competitor versus creator. So under godly, whatever you want to call it, source, covenant, everything connects to one, as you were saying yesterday. You were basically describing covenant at the top there. But when we go around pointing fingers, that's different spirit. It's not spirit of one, it's competitor spirit. Right? And people immediately feel it. So until we turn up with something that's in creator spirit, they can't hear us. But I can now look back on things I've done, pushing back on the system and go, oh my goodness, I did what? Yeah, that's okay. Because that was a necessary waymark on the learning journey to get to the place where I didn't have a neutral framework, right? Well, now I do. So I've got a way of engaging the system without condemning it automatically.
Okay, I've got two questions for you. We send notices to the DVLA and to come off the electoral register, so I'm not asking you to be my counsel, but we sometimes, not all the time, get a letter back which quotes acts and statutes, which we know we're wrong. You were intimating So we need to know, one, do we just ignore the response and carry on and say, come off the electoral register, or I don't want to be registered with the DVLA, or can we put it into this system you said? So the question is, can we use the needs that we have to answer the question to...
Right, so I've got a whole bunch of mates who've been applying the framework. So I developed it. I think it's just a fact in the world. I just happen to have given it a name and described it, yeah? It's to HMRC, Treasury, banks, the whole, Bank of England, doing loads of freedom of information requests. So until there's an agreement as to what accountability would look like. So what this attribution thing is doing is it's basically redirecting responsibility. That's what it actually does. Yeah. Where does responsibility ultimately land? And when the system feels threatened, it degrades attribution and sends it off somewhere else. Yeah. It's generally into an abstraction of some kind. The statute let me do it. Yeah. Or I've got this. I can quote this court case, even though it's not relevant. That gives me the authority to do this to you, right? It's so it recedes into abstraction. So until you can agree with them up front as to what accountability would look like, what level of abstraction and what level of truth regime, you keep talking past each other. Yeah? You can't really hold them to account. What you need to ultimately do is get them to say in their own language, this is what would count as accountability. It's hard. So I'm working with people to kind of learn how to break the thing down into a series of little problems which can be picked off with FOIs or appeal or whatever it is, which then when you compose them together give you the accountability you want. Because you generally can't get it in one go. Just like my court naming thing, I've taken the single justice procedure away from general magistrates' courts, and out of the whole of the single justice procedure, I've chosen one tiny little bit of it to ask the High Court to clarify in Part 8. It's not going to take out the single justice procedure. It's not going to fix the court naming issue, but it just establishes one little datum far upstream that I can now ask this question about, and this one, yeah, downstream. So it's kind of an information modelling and causality problem, which is exactly the thing that safety critical systems engineers do. I used to work in telecoms, modelling performance hazards in telecom networks. Right? All I've done is take my existing tech knowledge and applied it to law. It's not novel. Yeah, I've not done anything special at all. Really, I've just taken really basic ideas and applied them to law. But without that thinking, I'm looking for justice. I want justice. I want to win. As long as you're in that mind frame, you keep losing because you never get to the intermediate neutral place of just evaluating it for what it is.
Martin, just a quick point. I can perfectly accept what you're saying in the sense of like, yeah, the system must go on, or the show must go on, or the greater good, all that kind of stuff. So it kind of continues kind of with its failings a little bit and here and there. The issue that I guess now we have, maybe in the past it may have been valid and possibly acceptable, to keep things going. But obviously since COVID and then the tyranny aspect of it, and then Israeli influence and all that kind of stuff, I don't know how that...
So sometimes the show should stop. So Nuremberg said, I follow procedure isn't good enough. Right? That excuse, if it's safety of life and you just follow procedure, sorry, I think a lot of people are about to find out the hard way around the COVID stuff that I was doing what the newspaper told me. Well, isn't an excuse. You're still accountable.
Yeah, systemic things like family courts, etc.
Right. So you can see how that routing happens. The newspaper told me it was acceptable to do this. You've rooted responsibility through attribution to rhetoric, yeah? Rather than, no, actually I'm accountable for putting the needle in the person.
Any more questions? Yeah. No, I mean, in general, it's a sign of an amazing job done when there's less questions.
Just want to say thank you, Martin. I've been following your work for a while, and you've actually provided insight, which is no surprise to me. We've been looking at certain aspects. So my question to you is, what are your thoughts at this stage about getting that neutral platform in front of as many people as possible in this type of a process? Do you think that's even the way to go?
So even as I've been sat here the last day or two, I've been thinking about this. So I've only developed this thing from my own, I don't know, I had to, in order to model what was going on in my court cases and not make a fool of myself. So I've been thinking maybe it's time for me to go on the road a bit and share this with people. I used to do workshops around telecom performance engineering. So maybe it's time to do some workshops around this, get people to bring in their own problems. We can run it through AI in the room, see what it produces and how to act upon it. Now, I've produced oodles of intellectual infrastructure, it's a technical term, oodles, but I haven't yet packaged it up into formats that other people can easily ingest yet. I think there is like an operating system of this stuff that just needs to be codified. And the ability of the system to exceed its attribution authority is about to be collapsed. That's what they're doing, yeah? And the AI audit of this is the mother of all audits. So all these systems that are using rhetoric and override, when they should be using procedure and formal attribution, boom. But we are then in a place to help them fix it, but without condemning them. And that's the loving place to come from. They can hear that. But not the ordinary operative. But my mum used to work in the back office of the court. Yeah, I'm not going to condemn my mum for having worked in the court. Condemn.
Martin,
No justice there.
These conversations obviously I was going to have with you privately, but for the sake of everyone here, should we start it now? What and how, or if at all, do you see the potential of your work working at the top and understanding the attributions and the framework that precedes all of the narrative, detail, fact-finding, evidence, organising chaotic data, mapping to case precedents, understanding the human experience of my sovereign truth that we're working on? How do you see the two dovetailing to be able to combine them together to be able to produce the whole picture, so that, like you say, from that, once you've got the whole picture and the attribution inflection points of someone's personal experience and case, how would you, that would then give a strategist or a judge or a barrister or your solicitor or your assistant yourself the ability to see the whole picture, and then you can pick which parts you want to hang your hat on.
Okay, so it takes me back to the very, very first thing I said, which was that door, right? Which is start with modelling boundaries and thresholds. Now, as it turns out, I used to work in recursive internet architectures, and it's only boundaries and thresholds. It's just boundaries within boundaries within boundaries within thresholds. Yeah, it's like so understanding the jurisdictions within jurisdictions within jurisdictions, so that the problem decomposes in the right way, makes it tractable. So you only need to solve this for like one little area and understand the meta method, and then as long as you haven't coupled everything together in some nightmarish mishmash, it starts to fall apart in a way that you can actually reason about. But it requires two things. Firstly, we're understanding the spirit we're operating in and maintaining the same spirit all the way through it. So the moment it goes into accusatory mode, it's failed. Yeah, it's an engineering problem. And what doing? Spirit and never mind. Brain fart.
Martin, just so what I'm seeing the issue in my, from what you've said, is that right now what we have is obviously judges, etc., paid by the state. So it's a coin toss between impartiality and partiality when it comes to hard decisions, possibly, where they've got to keep the system going, etc., and maybe trial by jury. is maybe the only impartial way that we might have.
Right, so you're hinting at the balancing of the facts and proportionality and that part of the justice system. I'm at the moment more concerned that there's the jurist part, the hard law, and the prudence part, which is the soft law. Yeah, is technically it might be possible to do this and enforce the contract, but it's really unfair. So that's not. Yeah, it's so in most of the jury type stuff, is this just? Is it fair? Do the facts support the charge? I'm not trying to adjudicate that. Maybe we'll get down there. That's a harder problem. I'm just trying to make sure: was there jurisdiction? Was there standing? Was there service? Is there an evidence chain that supports the basic building blocks? Let's start with the simple stuff first. Yeah, it's managing chains of evidence and how they support various conclusions much harder. And the critical part to this, I think, is not so much modelling law as modelling not law. Right? So part of what I've been developing is a set of tiered model of voids. So normally we just say that's outside your authority. It's ultra vires, it's void, it's null, we're done. Yeah. But actually, what we need to be able to do is have a fine-grained model of exactly how it went beyond authority to classify it and then correct it. So it takes someone like myself who's not a lawyer and would never want to be one to come along and say, I'm not interested in participating in the game, I want to know where the edge of the game is. And actually I can be an expert in not game. Because I live in the ordinary world, but I'm not in your game. I'm not a lawyer, I wouldn't want to be. So I'm focusing on the exterior of the game and the boundaries of the game first, and the deep interior, difficult problem later on.
Yeah, last one. Again, fantastic. I wasn't asleep, I was digesting the information. Right, I don't know if there's any David Icke fans here, but I'm not a David Icke fan, but he does say something that's always stuck with me. Problem, cause, solution. We know what the problem is, and we know what's causing the problem, but what is the solution? Well, the solution is simple. The debt has already been paid. Okay, we know that. So it's changing the record. So everything that you guys have done, or doing, and what the guy in the cap said, we have to change the record. The only way we can change the record is to play their system, which is what you're doing and what this guy's doing. But how do you win? Well, how do you win is you recognize the problem. We are all in sin because we are controlled by the birth certificate. So when we get to a high court, you can't do this in a family court. This is where the children issue is deeper than what you're saying. But if you get to a high court, the first thing you ask for is, I do require you, Your Honour. Do is a very powerful word.
Yep.
I do require you to forgive me because I'm in sin. What have you just done? You've just put yourself in the highest law of the land, which is equity.
Right. And
under equity, there is a requirement that if a wrong has been done, there must be a remedy. I'm going back to, I can't remember, we talked about trust law yesterday, I can't remember now. But the highest officer in trust is the executor. Now what the legal system has done is made us, through the adverse ownership of the birth certificates, it's made us the debtor, and it's also made us the trustee. So a trustee has fiduciary responsibility, that's why we have to pay the debt. But once you say, do forgive me, you put yourself in equity. And if you go in as the living man and the living woman, as in birthright, you are now in the highest law, and there's nobody above you. And what you say to the judge is, I am the living executor. The accused, which is the birth certificate, is the principal beneficiary So under trust law, Your Honour, there is only one position left. So that makes you trustee, and you're the trustee, so therefore you have producer responsibility to settle this case.
So you touched on something profound and necessary. I ran a one-day course in Chiswick about a year and a half, on spiritual exit from the law. So we're only under the law to the extent we're operating in self-will. So when everyone operates in divine will, they don't have a neighbour that's arguing over the height of the fence, because they take it to their church, not to their courtroom. All right? It's so you're describing the highest when people go under the law, the highest level versus there's a whole tier of levels you can be at and levels of standing. But there's also not under the law. So if we don't do anything in self-will, we don't put ourselves under the law. And this is where a lot of sovereignty arguments fall down, because I don't consent, well, how high is the hedge? Yeah. It's who's going to arbitrate? You're shouting at each other, you're breaching the peace. Oh look, you put yourself under the law. Yeah, it's you didn't consent, that's a shame. The justice of the peace is here to keep the peace, bind you over. So the sin part is actually integral to all this, but that's another whole day seminar, not a 30-minute.
Discharging the charge. Thank you. What I really love now is you're just bringing these minds together that are way more clever than me, and collating, sharing this information, and making it work for everyone. It's awesome. Due to the fact that we seem to be having a technical breakdown, I'm going to ask Mark Bowlerhat to come and give us a quick update as to where you are now. Thank you, Martin.